This is Protiviti Legal Perspectives.
Welcome to Protiviti's Legal Perspective podcast series. I'm Shad Volkert, your host of the show and also global solution leader here at Protiviti. I couldn't be more excited today than having Melissa Cohen, Managing Director of our legal consulting practice, on with us today. Welcome to the show, Melissa, and maybe share with our listeners a little bit of your deep expertise in the legal field.
Sure, Chad. Thank you. So excited to be here. So like Chad said, I'm Melissa Cohen. I'm a managing director in legal consulting. I spent the first almost 20 years of my career, even though I'm still, only 25, working in Big Four accounting in the forensics practice. So by trade, I'm a CPA and certified in financial forensics. And my practice focuses on forensic accounting investigations involving fraud, whistleblowers, misappropriation of assets, and helping corporate clients and outside counsel alike prepare for and respond to any unplanned events.
Maybe speak a little bit about managing sensitive issues surrounding internal fraud and investigations, how you do that in partnership with your clients and outside counsel, and how technology can either assist or hinder some of that process.
Sure. So when I get on the phone or in a meeting with a client, the first question is, have you notified outside counsel? And is your general counsel's office involved? Because any sort of potential misdeed, you're going to want the coverage and protections for our attorney work product. So I usually kick off the questions asking about their involvement. And if they haven't notified, I suggest that's the first step we take. Typically on these types of projects, we are engaged by outside counsel so that we are protected under the same privileges that they are. As for our teams, we make sure that everyone understands the confidentiality aspect of it, and whether that includes putting any sort of disclaimer language on any of our deliverables or communications, making sure that phone calls, meetings are not recorded or transcribed if that's not something that the attorneys have approved. That is something we are always aware of, and make sure that we're letting our team know from the top down what's permissible and what's not when you're working under attorney-client privilege. With respect to technology, where we're seeing the most traction, obviously, is with collecting devices, email, Teams messages, computers, servers, and the like. So we go at it with our technologists to go and collect and preserve the data, process, and host, which we do all together as a team, working hand in hand with our consultants and with our technologists.
And as you've begun to share this collaborative nature between in-house counsel and other corporate stakeholders and outside counsel, those trusted legal practitioners, how do you begin to mold that collaboration with your deep expertise and the expertise that your corporate client and law firm need in and around these investigations and or litigations?
Sure. So I would say communication from the start is the most important facet of starting one of these projects. We want to make sure that us as the advisors and consultants working with outside counsel and the general counsel's office and any other key stakeholders at our clients, we want to make sure that we are all following a mutual work plan. We all are working towards the same goals. And in there, we would divide and just say whose responsibility each task would be, so that we're all working together, but in our areas of expertise. Where we see these potentially go wrong or hit some hurdles is when any member of the team, depending on what work stream they are, operating in a silo. And therefore, they're not truly acting as a cross-functional one team approach to the project. So what we like to do is, at the beginning, plan for how periodic updates are going to occur, who's going to be on calls, who's going to participate in meetings, what the deliverables are going to look like, and what our objectives are for each step of our work plan, so that we're all working in tandem and working towards the common goal. For me, I like to have as many representatives of each of the work streams that are involved be included in these conversations, because everything is interrelated when you're working through an investigation. So what our technologists are going to be supporting, what our accountants and our advisors are going to be testing, and what our attorneys are going to be looking into, they all have a certain piece of the puzzle, and everyone needs to know where everyone's working so that we can see how all these pieces ultimately fit together.
Well, I mean, what I'm hearing loud and clear is collaboration and transparency. Obviously, I'm sure there's moments in time of the investigation where a small group needs to get together, but the more broad-based collaboration, one team, sort of hashtag one team and transparency, the better off you are. Maybe just taking a step back though, right? Because I know a lot of the incident response and requests are sort of 911s as you're getting involved, but I know you're doing a lot of proactive advisory work with corporations on how to prevent the need to actually conduct the investigation or getting involved in litigation. So maybe walk our audience through a little bit better about how, as a corporate stakeholder, you can position yourself to avoid some of these risks and be more proactive in their approach with an advisor like you.
Sure. So much of these investigations are driven by data. So the most important thing for companies is knowing where their data resides and what the document retention schedule and mobile device policies are. This helps that when we come in and when and if there is an investigation or an inquiry, the client can efficiently obtain their data and know where it resides. We typically will come in and ask these sorts of questions, and our clients won't know the retention schedule, won't know how to put something on legal hold. They don't know where their data is being mapped to. So any sort of what we call litigation preparedness work that you can do beforehand is so helpful when and if there is an alleged misdeed that needs our support. We know where the data is. We know how to collect it efficiently. Also, I would say that having your policies and procedures at the ready, including any iterations that the policies have been through, is also something that is very helpful for us. Much of our planning starts with looking at the policies, procedures, standard operating procedures that are in place so that we can understand if there are any gaps that we can go ahead and address them before there is a potential event. So all of these things can help you be prepared for and respond to any sort of alleged misdeed more efficiently and quickly.
That's great. The idea around working hand in hand with a client to prepare for, unfortunately, the inevitable, most likely, but how to prevent that through a playbook and a design, right, of that structure and what happens if and when, I'm sure brings great benefit to your clients as you're moving them through the process. Maybe share with us if there were 2 red flags to look out for, right, as in-house counsel or a business owner and operator to try to prevent some of these things. What do you think those would be, Melissa?
Based on the projects that we've been working on for the last 6 months or so, we are still seeing a lot of instances where companies have data at the ready, but they aren't using it in a way that is proactively looking for areas that there may be the opportunity to take advantage. For example, if your client is using any sort of company credit card or procurement card, a lot of our banks provide level 3 data that'll give you detailed information about each of those transactions. However, that information isn't being incorporated into time and expense. So there is an opportunity for someone to take advantage of the system by changing what they're reporting. However, if data was integrated into that system, there's a lot more accountability and checks and balances to confirm whether certain expenses tie and agree to what's provided from a third party.
Again, awesome to have you, Melissa. Thanks for taking time out of your busy schedule.
Thank you for listening today. Find other episodes of Protiviti Legal Perspectives on YouTube and wherever you listen to your podcast content. And to learn more about Protiviti's legal consulting services, visit protiviti.com.